So welcome back. I'm Peter Yu. I'm teacher at Texas A&M University. So I'm originally from Hong Kong, so it's a lot of pleasure to be able to see a lot of you guys virtually, even though we cannot be in Hong Kong. We have spent time covering a lot of different issues, from conceptual to institutional, and then we talk about global issues as well as natural approaches. And so what we want to do in this panel is to zero on regional arrangements. So in the interest of time, I'm going to briefly introduce the speakers. If you want the full bio, you can find that on the website. And after all the speakers are presented, we are going to do the Q&A session. If you want to post any question, you can start posting at any time in the Q&A box. So our first speaker is Meera Boori. She's a senior lecturer at the University of Lausanne. She has done very interesting work on digital trade as well as preferential trade agreements. And many of us also know her work way back from when she worked at the World Trade Institute at the University of Bern. So without further ado, Meera.
Thanks so much, dear colleagues. Delighted to be here and very grateful to the invitation from Hao Chen and Anupam. Thanks also for the introduction. I will just start sharing my presentation briefly. All right, I do hope you all see it now. My presentation basically has two objectives today. The first one is to trace the evolution of rules on data flows that we have in preferential trade agreements and the current state of affairs with regard to design of these rules as well as to their diffusion. And the second objective, really in the light of the theme of this conference, is then to ask what this existing framework actually means for global data governance and what we may expect in the future. So my starting point of the presentation and indeed of the entire conference is the centrality of data for the contemporary economy and societies as a whole. And here the mantra of data being the new oil is of course well known. And although this is a somewhat flawed statement, as data is not necessarily exhaustible and its value may be lost over time, it is quite illustrative of the significance of data for modern economies. And this has been, of course, a push for both companies as well as governments to make the best of it. Although, as we saw yesterday quite clearly, in very different ways, so with different toolboxes and with varieties across jurisdictions. In the context of trade policies, the growing importance of data has had one crucial implication, and that is that data must flow across borders. Anupam has shown in an excellent way in many pieces how many of the things that we are used to in our daily lives, such as the app economy, outsourcing and streaming services, and if we think down the road, things like the Internet of Things and artificial intelligence would simply not function if there were restrictions on cross-border flow of data. Permitting these free flows, however, and we saw this very, very clearly yesterday, is not easy because the use of data and big data analytics open many regulatory questions as to the balance between access to and control of data and the protection of privacy, but also the protection of other societal values. Furthermore, we saw this again yesterday when data leaves the country, many jurisdictional issues arise. So generally rising these questions of data sovereignty that this very conference asks, as well as something that we didn't discuss so much, leading to new digital trade barriers. On the one hand, be it through sort of the EU GDPR, which post-Schrems II judgment functions as a sort of a soft localization measures, as also Anupam has shown, but also through sort of explicit, more restrictive interventions and data localization measures, such as in the case of India, as Neha showed yesterday. But we also saw quite clearly, and I want to underline this, that this data sovereignty comes at a certain price. Now, turning to the trade law framework that we have for data flows, First, it should be said that trade law often is sort of marginalized under discussions of global internet governance. And I will show basically today that although, as Anupam argued yesterday, the World Trade Organization is to some extent weak, the broader field of international economic law, driven by bilateral and regional trade agreements, has become an important platform for regulating data. In general, one can say that trade rules matter for data in at least three ways. First, because they do regulate trade in services, trade in goods, as well as the protection of intellectual property, because they may also install some beyond the border rules that demand changes in domestic regulation, for instance, with regards to intermediaries' liability. And third, and more generally, because trade law can limit the policy space that regulators have at home. And I think this is an important point that we may want to come back later in the discussion. So I lead a project that is dedicated to tracing all developments in free trade agreements with regard to digital trade. And we have created a data set in this context, which is, by the way, free to use under the Creative Commons license and is available on this link. And we see that increasingly almost all agreements have substantial digital trade provisions. And here on the next slide, you see how this development has become more rapid over time. And we have an increased number and density of this provision, so more words in the text of the treaties, as well as more binding provisions. Currently, the updated NAFTA, so the USMCA, has the most comprehensive digital trade chapter. But if we look at newer sort of digital trade dedicated deals, such as the one between the United States and Japan, and DIPA between New Zealand, Singapore, and Chile, they go much beyond, of course, what we have in the dedicated digital trade chapters. I just want to highlight sort of two important sort of developments in this overall evolution. The first one is that privacy protection has somehow become a trade topic, in particular in the recent free trade agreements, but it's also a topic that is very much contested. And the second sort of important development is that although we often talk about data flows and there is great policy debate around this, in fact, only few other agreements that have norms on data flows per se. In terms of sort of definition of what is data flows, here again, we have a widespread rhetoric around this term, but actually in the treaties themselves, there is no legal definition. The language might vary across different treaties. What is important is that we have a tendency towards a very generic, all-encompassing definition, which is not necessarily related to provision to one particular good or service. And this may actually be related to multiple flows of data flowing across borders. Something that we discussed yesterday is this possibility to have distinction between different types of data, personal versus non-personal in particular. However, we do not find yet such a distinction in the existing treaties. What is, however, clear, personal information is almost always explicitly included in the treaties. And here, of course, the potential clashes with data protection laws and the striving of the states to protect the data of their citizens becomes quite evident. In terms of the development of data flow rules over the years, of course, we have started with some non-binding provisions in very earlier treaties, such as the 2000 Jordan-US Free Trade Agreement. And over the years, this has been replicated in multiple agreements, still, however, sticking to this softer language, even in the 2007 South Korea-US Free Trade Agreement. Data flow provisions have more recently become sort of coupled with provisions on data localization. And unlike most data flow provisions, the data localization provisions tend to be binding. This is something to keep in mind in terms of the impact of these treaties on the ground. In terms of sort of new rulemaking on data flows, the template that we have that has been developed through the CPTPP, the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, clearly stands out. Here, of course, we need to be reminded that the template is exactly the same as under the TPP. So the United States stance here is clearly reflected. The negotiation power of the United States has been reflected also in this treaty. What the CPTPP does with regard to data flows is that it really tries to restrict the use of barriers to data flows. On the one hand, by having an explicit ban on localization measures, and on the other hand, having this hard rule with regard to data flows. Basically, each party shall allow the cross-border transfer of information, including personal information. The CPTPP is, however, not only about sort of bans and setting higher standards, as we normally actually expect from trade treaties. It is also about sort of lowering ones too, and this is particularly palpable in the area of privacy and data protection. The goal there has been clearly to sort of give priority to trade over privacy protection, and it has been argued that this came in the TPP negotiations very much as a sort of a reaction to the Schrems I judgment, which invalidated in 2015 the US-EU Safe Harbor Agreement and found that the level of protection that was provided in the United States was not adequate. What is quite impressive is the diffusion that we have of this template. So the post-TPP development, basically we have the same rules, the same hard language with regard to data flows in multiple agreements. And so there is a clear diffusion distribution of this template. With the updated NAFTA, we have also a sort of clarity on the US position. Basically, the USMCA replicates the template of the CPTPP with the same rules on data flows and extends it in some regard. What is interesting for me in this treaty is that we have also this language that tries to reconcile economic and non-economic objectives, and is somewhat even expanded with, if you want, compares with the CPTPP. There, what is interesting is that the United States, and this is for the first time, and in contrast to the agreement that it has with Japan, that it makes reference to some international treaties, to some international standards with regard to data protection, as well as mentions key principles of data collection and processing, including data minimization, purpose limitation, and others, very much here sort of even following the EU tradition with regard to these principles in this regard, which is interesting. This, of course, is a question: what has driven this? Is it like a sort of a repositioning of the United States, which may be or may not be linked to what we discussed yesterday, the so-called Brussels effect, basically the export of EU standards? As also, it should be acknowledged that in the meantime, a lot of the larger US firms have become GDPR compliant. At the same time, we have a newly endorsed counter model of the European Union. It should be acknowledged here that the EU has really repositioned itself with regard to data flows and treaty language with regard to digital trade. So if one compares to earlier EU agreements, including the one with Canada, basically we don't find much. We have GATS level commitments with regard to different service sectors that are relevant to digital trade, and some cooperation provisions, certainly no data language. This changed a little bit with the EU-Japan and the EU-Mexico agreement, where for the first time data flows were actually mentioned. However, again, in a very cautious manner, basically the parties simply state that within 3 years, they're gonna see whether indeed such provisions are really needed in the treaty. This is now radically changed, recently changed, with the currently negotiated EU deals with Australia, New Zealand, and Tunisia, which do have a hard language on data flows, as well as ban on localization measures. However, and this is here the difference to the US-led model, this language is paired with the high data protection standards of the GDPR, and it endorses clearly the protection of personal data and privacy as a fundamental human right. In addition to this, we have a number of other safeguards. The first one is rather broad, and that is the right to regulate that is defined in those treaties, which basically gives a lot of policy space to the European Union and its partners. There is also a time revision clause, which basically says that within 3 years, we're going to see how these data flow provisions really function, and then we might actually decide that additional safeguards are needed. So this is creates a different models, and one can say that we do see in this sort of universe of treaties this EU-led versus the CPTPP or the US-led model, and those models appear in contestation. For instance, the EFTA countries, Switzerland, Iceland, and Norway, are currently discussing to follow the EU model quite clearly. They do have some differences, but they are going towards adopting such a model as a model e-commerce chapter for all their future agreements. So we see here also some diffusion perhaps of the EU model. Just for the sake of time, I would simply wrap up and maybe highlight some open questions that we have in this discourse. Overall, what one sees is that we have increasing regulation of data flows and privacy protection in trade agreements, which in itself already opens a question whether trade agreements are at all the right venue to tackle such issues. We also have the question, of course, of this manner of contestation between the EU and the United States, which model would prevail, what would be the global diffusion of these different templates, and ultimately what are the implications of this contestation for any efforts that we have in the area of digital trade in the multilateral forum of the World Trade Organization, or some plurilateral efforts such as the joint statement initiative that we have. Another question that I did not pay enough attention to is the reconciliation mechanisms that we have. So this treaty language on how to reconcile economic and non-economic interests, mostly focusing really on privacy protection, and to what extent those are really viable. Do they really provide a proper balance of interests and enough policy space for states to really protect the fundamental rights of their citizens? It's also interesting, and this is something that Susan highlighted yesterday, is that we have, even in the EU example, we have a clear priority that is given of privacy over other human rights. And is this right? Is this the path we would really like to go? I mean, in terms of international law, of course, we do not have a hierarchy of the human rights. And here, again, as Susan mentioned yesterday, should we move towards another model, such as the one that was created with the Digital Economy Partnership Agreement between Chile, Singapore, and New Zealand, and which covers a broader sort of area of rights and tries to also, in terms of what Mark was talking about, tries to really promote trust in this digital environments. And ultimately a question that has not been actually researched, and we have very little evidence on what is the impact of this treaty language that we have coming from these trade agreements on data flows. What is the impact of this language actually on the ground? Has it spurred changes in domestic regulation? Has it changed the behavior of actors, be it companies, users, or state authorities? So these are just a few, of course, of the questions that might be asked in this context, and I very much look forward to the discussion later on. I have just recently won a grant by the European Research Council on trade law for the data-driven economy, and I'll be very happy to engage in a conversation as we move on, of course, on addressing these important questions. So thank you very much for your attention, and I look forward to the discussion and the questions afterwards.
Thank you, Mira. We now turn to our next speaker, Graham Greenleaf from the University of New South Wales. He's a leading scholar in privacy and data protection in the Asia Pacific region. He's also a longtime friend of the University of Hong Kong. I believe now it's 2 a.m. in Sydney. So Graham, thanks for staying up for the presentation.
Good. Thank you for the introduction, Peter, and thanks to Hao Chen and to Anupam for their invitation to me to be involved in this project. I'll just get my PowerPoints up on screen. So just at the wrong end. There we are. Well, what I'm wanting to do today, ladies and gentlemen, is to take a broad view of the notion of data localization. But as we heard from various speakers yesterday, data localization also applies to non-personal data, and all I'm going to be looking at is the personal data side. And my starting point is that it seems to me that some definition of data localization are too narrow. Dan Savanderson, who you heard from yesterday, in his very recent report to the OECD, described data localization in terms of that data be stored or processed within a specified jurisdiction. So he's only looking at the storage and local copy aspect. Whereas Chanda and Farrakhan identified in their categorization four types of cross-border, four types of localization. Cross-border data transfers, which included conditional exports, local storage, local processing, and export bans. And while that's much broader, I don't think it's as broad as is most useful. And so what I'm proposing is a broader definition and consequent recategorization of the notion of localization. And the sort of type of definition I use is by posing the question of how do states exercise control over the processing of personal data such that processing in another state is affected. Or another way of putting that is, how do local rules about processing of personal data affect what processing can be done in other states? And I think if you take that approach, what you get is that there are 6 different categories of data localization that come under this broader definition. The first is the local copy or processing requirement that Dan Savanderson referred to, which I call localisation number 1. And for convenience, I'll use this sort of 1 to 6 numbering of forms of localisation. Secondly is exports being allowed subject to conditions, number 2. Third, exports prohibited. Fourth, and this is where the real difference comes in, the extraterritorial application of local data privacy laws, I would regard as a form of data localisation, because what it means is that even if personal data is processed overseas, a jurisdiction asserts that its local rules apply. And as Thomas Stein said yesterday, the EU has basically convinced the world to accept that this is a sensible aspect of data privacy laws, and it's certainly a most important one. Following on that, local representation requirements are also a form of localisation, because they can be essential to make the fourth or second form of localisation enforceable. And sixth, I mentioned something here that's not a form of localisation, what I call outsourcing exemptions. It's sort of the inverse of data localisation, where a jurisdiction abandons its own local sovereignty when personal data is imported into the jurisdiction for processing. Now, I would argue that to really understand any one particular form of data localisation in a jurisdiction, you need to look at at least the first 5 of these forms of localisation together. Now, there are many nuances that flow from this, as Savanderson and Chandra and Ferrachan point out. De facto localisation can occur when the conditions for exports are so strict that only local copying or processing effectively becomes possible. But that notion of de facto localisation is broader too, because what we can call GDPR creep occurs when there's a de facto adoption of the extraterritorial effect of the GDPR. Secondly, the scope of localisations can be very variable. They may apply only to specified categories of personal data, such as sensitive data, as occurs in some cases, or critical data, as is defined in other statutes, or they can apply to all personal data. And as a result, you get many combinations of localisations that are possible in a jurisdiction. All 5 can be possible if localisation 2 and 3, the conditional exports and the ban on exports, apply to different categories of personal data. So the EU, the GDPR, combines the 2nd, 4th and 5th of these forms of localisations. Russia combines the 1st only in relation to Russians, the 2nd and the 4th. And as a generalisation, the US normally doesn't include any of them. So with that introduction, I'm trying to stick to the topic of the geographical focus of this seminar in relation to the Belt and Road, by looking at 2 particular geographical areas of the Belt and Road. South Asia, where you can see on the map that important parts of Belt and Road are Gwadar in Pakistan and Colombo in Sri Lanka. So we'll look at South Asia. And of course, then there's the many aspects of the Belt and Road that flow through Central Asia. But by framing it in terms of Belt and Road and the Digital Silk Road, the starting point, of course, has to be China. And to understand it very briefly, China's approach to data localization, the easiest place to look at is the very new draft law of the People's Republic of China on protection of personal information, which was released by the Standing Committee of the NPC only a couple of months ago. Now, starting with the conditions for data exports, what we see here, and I won't go through all of these, 4 different types of conditions, one of which must be satisfied for personal data to be exported, but all of them depend to a large degree on discretionary decisions made by the Cyberspace Administration of China. And then there are additional conditions such as consent of the data subject that must be satisfied as well. So you have a very discretionary form of conditional export. Now, because of that discretionary control, it effectively equals the CAC having the discretion to prohibit some categories of exports completely, which may occur, which is a de facto exercise of the prohibition form. Now, so China's approach, I think, contrasts quite a lot from the quasi-legalistic processes that are involved in EU adequacy, with various decision-making parties involved, up to and including the CJEU. But then as well, China includes in its provisions all the other forms of data localization that I've mentioned, where personal information is collected or generated within the PRC at the volume provided for by the CAC in its discretion. It must be stored within PRC territory, so that's localization to be number 1. China has also included extraterritorial application of its law to processing outside the PRC in forms very similar to the GDPR, but with an additional, as yet undefined, set of other circumstances. It includes provisions for designated representatives where processing is to be within the PRC, where overseas processing is brought within its law. And it also has a unique provision, as yet at any rate, allowing the PRC to take retaliatory steps concerning personal information against companies or countries for any processing or discriminatory measures that are considered to harm the PRC. Now, this is a novel form of data localization provision, more like provisions in a free trade agreement, but unilateral. So China exercises all of these forms of data localization, and the overall effect is a very strong assertion of PRC data sovereignty, or data localization, if you like to put it like that. At another branch of the Silk Road, on the other side of the Central Asian countries, is Russia's data localizations, which provisions, which are very different from those in China. But in the case of the local processing and storage requirements, which date from 2014, but only apply to personal data of Russian citizens collected in Russia. That's the aspect of Russia's law that gets all the attention, but there are other aspects of data localization as well, with some surprising aspects for their conditional allowance of data exports. So the result is that Russia has the first, second and fourth of the localizations that I've identified, but really it's only the terminology for the second one that has had any notable influence on Central Asian laws. So now I'll just look, what'll have to be briefly, at the two regions on the Silk Road that I said I'd mention. The first being South Asia, and looking at Sri Lanka, India, and Pakistan. Now, all three of those countries are in the process of enacting data privacy bills at present, and therefore, in that sense, they reflect recent thinking taking place in those countries. I've set out the details of those three bills there, and we'll wait and see how long they take to be enacted. But all three of them are very strongly GDPR influenced bills overall, but they all differ from the EU on data localization. But two of these countries, Pakistan and Sri Lanka, are supposed to be important aspects of China's Belt and Road and Digital Silk Road initiatives. But on the other hand, sorry, that's where it should be. But on the other hand, India has been very critical of the Belt and Road and has no real involvement, but nevertheless took an extremely strong data sovereignty-based dissent at the 2019 G20 meeting. There are no significant regional data privacy initiative in the South Asia region, although I've noted a couple of aspects there that are relevant. So India and Pakistan have been influenced by China's data sovereignty rhetoric, but not really the details too much of the actual Chinese legislation. Now, in the next two slides, I've set out, according to the 6 types of localization I've identified, how each of those countries has implemented them in their bills. Now, the overall points here, because I can't go through all this in detail, is that there is a very considerable number of localization provisions, but they differ a great deal between all three of each of the three countries. And although they all refer to something like adequacy as the basis for conditional exports, they have a considerable amount of discretion as to what adequacy means that is not written into the legislation, which makes it somewhat distinct from the EU's approach. So there's the comparative charts, and I mentioned at the last category there, outsourcing exemptions, that India and Pakistan both have outsourcing exemptions. So in India, the government can exempt specified processing of personal data on a category of foreign nationals not present in India, which might suit very well outsourcing from the US, but would not be suitable in relation to the EU. And there'll probably be a lot of pushback from the EU when India again tries to obtain an adequacy finding from the EU. On the other hand, Pakistan has a provision, a very ingenious one, that foreign data subjects retain any rights they have under the laws where their data is collected or the subject resides. Which
Sam, you have 1 more minute.
Yeah, okay, good, fine. So the conclusions on South Asia here I've set out, but it is that all the bills have very strong but very different localization elements. and that China's influences are fairly indirect. Now, just very briefly in relation to Central Asia, all 5 countries in Central Asia have new or revised data privacy laws since 2017, but not implemented all that much as yet. China's Belt and Road Initiative was launched in Kazakhstan in 2013, but from a study in The Diplomat published very recently, even though China is becoming the leading regional investor now, Russia's institutional legacy still persists. This is consistent with what has happened with China, with the localization provisions in Central Asian data privacy laws. Now, once again, in my PowerPoints here, I've set out this 6-part comparison, but the result is, and I'll finish on this point, that neither Chinese nor Russian influences are very apparent, despite their proximity to the Central Asian countries, except Russia's law has similar drafting in relation to conditional exports. And I'll stop there and go to questions.
Thank you, Graham. Our last speaker is Professor Theodore Christakis from the University of Grenoble. He holds the chair in legal and regulatory implications of artificial intelligence, and he's going to take us to Europe.
Yeah, thank you very much. And I hope that you're able to hear me and to see my screen. If this is not the case, please let me know. I would like to thank very warmly Anupam and the organizers for this extremely interesting conference, and Thomas, who has already launched the debate about European digital sovereignty yesterday. So I will continue from where he stopped, and I will refer to a recent study I have published just before the holidays on European digital sovereignty. And I would like to start, we've been talking about sovereignty for 2 days now, and it is important to understand a little bit the term and to ask the big question. The term sovereignty means a lot for lawyers, but does the term digital sovereignty makes any sense for lawyers? And this is an important question because we all know that the concept of digital sovereignty is highly controversial, ambiguous, but the concept of sovereignty also is ambiguous, and one could wonder whether the concept of digital sovereignty could just accentuate the classic confusion surrounding the term sovereignty. As a matter of fact, the term sovereignty is extremely ambiguous. It is the champion of all adjectives and definitions. I don't know if somebody has his micro, if you could mute your micro, please, so that there will be no interference. The champion of all adjectives, if you look at the literature, including very famous scholars on the term of sovereignty, you will see that there are so many descriptions of sovereignty about being plural, pluralistic, fluid, elusive, vague, dynamic, evolving, changing, imprecise, interdeterminate, confusing, controversial, equivocal, polysemous, ambiguous, pivotal, abstract, mysterious. This was my harvest, and there are others who have argued that sovereignty corresponds to a philosophical fiction, to a myth, which exists only at an ideal level. And for all these adjectives, we have also a lot of definitions. Two scholars in an article were able to list 16 different definitions. In reality, depending on who you are, you will not define sovereignty in the same way. The term is used in a very different way by scholars and between the scholars, between, for example, international lawyers and constitutional lawyers and other lawyers, by journalists, politicians, international civil servants, and others from different cultures. And we could also consider that the term sovereignty is the champion of all controversies. The concept of sovereignty in classical legal literature has given rise to an impressive number of controversies throughout the history of the term. Scholars have focused on one or another of the definitions of these several definitions, much more than 16 in reality, in order to show that these definitions are no longer relevant or that the concept is increasingly anachronistic. And we could mention also the fact that the concept has been the target of ferocious attacks because of its abuse in history and misuse by politicians, authoritarian regimes, and others. Don Herzog, in his recent book on sovereignty, wants to bury it once forever, but he concedes that this is a zombie concept, undead, stalking the world, terrifying people, while Neil Walker recently wrote that some of the most powerful pushbacks against the post-war international legal order, such as Brexit and other things, or Trump's discourse, are based on sovereign nostalgia. So all this make us think of what Louis Hankin once famously said when he said that sovereignty is a bad word, not only because it has served terrible national mythologies, but also because it is often a catchword, a substitute for thinking and precision. So when one considers all this and comes now to the concept of digital sovereignty, we understand that the concept of digital sovereignty is very much, makes little sense from a normative point of view for several reasons. And we could consider that different states use the term in different ways in order to promote their political agenda, and politicians can carry out, using this term, very different projects. In the EU, the use of this term, it's become extremely fashionable. Graham just talked about China and Russia and India and Pakistan. It's very new for the EU, and it makes little sense to talk already about sovereignty in the EU. The term sovereignty is not to be found anywhere in the constitutive treaties of the EU, let alone a digital one. And when Jean-Claude Juncker, the president of the European Commission, proclaimed in 2018 that the hour of European sovereignty has come, well, everybody criticized him. But it seems that times are changing, because now the term digital sovereignty, you can find them in the most important documents. It's used by the European Council, etc. And when we look at the literature, and this is what I try to do in my study, we see that it is used in two ways. And this is where I will focus in the remaining of my presentation. It is used, the term sovereignty, digital sovereignty, is seen as a power to regulate, what is going on in cyberspace and the digital sphere, including the activities of big tech. And the second conception of the term is digital sovereignty as a way to achieve strategic autonomy in the digital sphere and to boost European competitiveness in tech. So if we take the first conception, in my study, I express my surprise about the discourses which try to present Europe somehow as a powerless entity, unable to regulate the digital sphere and big tech companies. This is a very classical discourse, for instance, in France, which is very striking, because Europe is the champion of regulation. And in my study, I use Anu Bradford's concept of the Brussels effect. Anu Bradford very well explained how Europe has been able not only to promulgate regulations in different fields, but also to influence the world. And Thomas referred to this also yesterday. As Anu Bradford writes, this led to unilateral regulatory globalization. The ways to do this are very interesting. The EU is using several ways, of course, hard rules, all of these regulations and directives that you all know the GDPR, but even recently, the EU adopted a series of very important data acts, projects of data acts presented by the Commission, the Digital Governance Act, which is the prelude to the Data Act, the Digital Service Act, the Digital Markets Act. Anu Pam said in an exchange on Twitter that I'm just waiting for the Digital Data Act, which has not yet been conceived. And this shows you all these hard rules, but have all these soft law rules also, where very influential codes of conduct, etc. We have the action by regulatory authorities. See what happened recently with the guidance by the European Data Protection Board on Schrems II, for instance. It's discussed all over the planet. And we have, of course, also the case law of the Court of Justice of the European Union. Sometimes when the Court of Justice sneezes, the whole data planet, data sphere catches a cold, as we have seen with the Schrems II judgment again. So from this point of view, it is interesting that analyzing my study using also Anu Bradford's thoughts, how in the digital sphere Europe has been so influential. One of the things to notice is that, for instance, not only countries follow this example, but also very often the tech companies promote European rules after lobbying sometimes against them for one reason or another. And this is really striking. And states also, of course, adopt, even before the GDPR, more than 120 states had followed European privacy rules. Of course, this regulatory power has limits, which are both internal and external. I will not cover them here because I don't have the time, but internal, for instance, there are a lot of times disagreements, for instance, between EU member states on some issues, such as the digital tax. There are legal obstacles, like, for instance, we have seen all this with the Huawei debate and 5G, because the constitutive treaties do not permit normally the EU to intervene on issues concerning national security and other internal obstacles. For instance, there are huge debates right now about whether we should go far enough in the field of AI regulation. And there was recently a letter by 14 member states saying, hey, take it easy because you will hinder innovation if you go too far. And there are external obstacles also. We can see in some specific fields that there are situations, classical in international law situations of interdependence, which render international cooperation necessary in order to avoid retaliation, to find constructive solutions, and to resolve conflicts of laws and jurisdiction. And we can see this, for instance, with the current negotiation between the EU and the US on a Cloud Act e-evidence agreement, among other things. So, of course, saying that the Europe is a champion does not mean that this is the end of the world. The chairman of Bruegel think tank wrote an article about the fact that referees don't win, and probably Europe missed something by regulating, missed the boat of building giant internet platforms and big companies. But in reality, this is true, and this is why we have the second part about strategic autonomy, the quest for strategic autonomy. But one should definitely not underestimate the importance of the Brussels effect. There is a titanic struggle going on for regulatory dominance, and Europe is very well positioned for this. So when we're talking about strategic autonomy, this is the second part, and I will go very quickly. This is based on a series of legitimate concerns. Geopolitical concerns are very important. Especially we are in a situation after 4 years of the Trump administration where international multilateralism has been harmed, and the US withdrew from several major international agreements and organizations. And there could be a tendency in Europe also, not only elsewhere, but also in Europe, to make Europe great again, to adopt such a kind of attitude. And also talking about geopolitical concerns, Europe is also caught in the middle of a developing tech war between the US and China that we all know the Cold War 2.0 has been called. We have seen the developments with the Clean Network Program and the efforts of the US administration to influence EU member states. Dependencies also, don't have the time here to explain this, but member states in the EU are entirely dependent very often on digital services, infrastructures, and components whose development, production, and operation are largely beyond their own control and authority. We can see this in several fields: cloud computing, high-end microchips, AI, and other fields. And the COVID crisis only accentuated this feeling. So from this point of view, the quest for strategic autonomy opens several opportunities. Europe has announced big projects to fund research and innovation, to intervene in some key fields for digital sovereignty, like quantum computing, high-end microchips, cloud computing, cybersecurity, and AI. And there are several projects going on that I describe in my study, and I cannot repeat here. But if there are opportunities, there are also potential pitfalls that should be taken into consideration. And this is the last part of my presentation. I would like to talk a little bit about these pitfalls. Especially, there are 4 kinds of pitfalls that Europe should definitely take into consideration before enacting some policies. The first pitfall is the risk of creeping protectionism. We must say here that Europe has been accused in the past of being protectionist. Some people said that the GDPR is a protectionist instrument. I don't believe so. And most of the observers have found that Europe is much more a tough regulator, as said Anu Bradford, than a protectionist entity. Nonetheless, there are several new projects which could give the impression of a creeping protectionism. And of course, restrictions can be based on legitimate reasons, such as cybersecurity reasons, privacy and data protection considerations. But on the other hand, we see that even within EU member states, not only external observers, but for instance, Politico talked about a coalition of 19 countries who said that there is eventually a tendency towards protectionism by other countries. So this is something to take into consideration, because protectionist policies could have adverse effects that are examined in detail in this study, including eventually the risk of violation of international law. We talked a lot about World Trade Organization and trade agreements. And I'm always hearing here that we need an Airbus, we need protectionism, we need an Airbus for the digital sphere. I think that Airbus is very, very different. And let's not forget about Airbus, that very recently the World Trade Organization authorized the US to adopt $7.5 billion in tariffs against the EU. The second point, I'm almost done, Mr. Chairman, is of course data localization. And after hearing all the things that Graham said about other countries, we could go very far in discussing this new push towards data localization in Europe. This is new. This is new. Europe was always against data localization. Europe was always criticizing all these countries that Graham and the others, not only China, India, Russia, and others, very powerfully. While what we see is that we have a push, and the Commissioner Breton made very strong declarations. He said, for instance, recently that I have always said that I want Europeans' data to be processed, stored and processed in Europe. The Chinese and the Russians are doing it. We will do it too. And there are huge discussions going on right now about both localization of personal data, especially in relation after the Schrems II judgment of last July. A lot of DPAs called for data localization, but also for localization of, and this is also new, of non-personal data. And there were very strong projects in the Data Governance Act. They have been a little bit nuanced, but still there are a lot of discussions about data localization, and we really need, concerning data localization, to think in Europe about the eventual costs, economic costs, cybersecurity costs, the risk of policy inconsistencies, because Europe has always been against, and implications for human rights. NGOs have strongly criticized all the things that Graham presented concerning data localization policies, which could have very adverse consequences for human rights. And one could ask, of course, Europe does not want to do data localization in order to harm human rights, but what will be the message sent to the rest of the world? Two last points, Mr. Chairman, just 1 minute. There is a big question, which is what internet model Europe wishes to promote. When you hear Commissioner Breton saying the Chinese and the Russians and the Chinese do it, we will do it also. You say, hey, just a second, Europe was always presenting herself as promoting a third model. President Macron made famous declarations about the fact that we have, on the one hand, the California, the US model, which is business above all, and the Chinese model, which is the authoritarian model, a surveillance model, and Europe is the third way. So suddenly now we're hearing more and more people in Europe talking about adopting Chinese policies that Europe has always criticized, against protectionism, against firewalls, against surveillance. So this is a little bit concerning and needs some more thinking about what kind of model. And the last point, we're hearing a lot of things in Europe under the digital sovereignty discourse about picking up champions, helping some big tech European companies become even bigger and develop cloud. And one could say that this leads often to a schizophrenic competition policies. Recently, the Commission proposed the Digital Markets Act, and there were calls to exclude the only European company, Booking.com, which could be considered as a gatekeeper. This is bizarre. And also governments seem to have a very poor track record of picking up winners. For instance, France tried to use taxpayers' money in order to create Quero, search engine to beat Google. And the simple fact that you have to Google Quero instead of querying Quero tells you how that fared. And same thing for the sovereign cloud. So this is what I wanted to say. The digital sovereignty concept in Europe does not really make sense from a normative point of view, but it's a very useful tool in order to discuss all these issues. Thank you very much, Mr. Chairman. And here is the link to my study on suzerainty.
Thank you, Theodore. So I've collected 5 questions. So what I'm going to do is to summarize all of them briefly. And in the interest of time, please hold your responses and please pick and choose whatever you want to answer. So the first question I got is from Brian, who is going to moderate the next panel. And his question is about the LCEP. And so it seems like the LCEP is going to be weaker on data transfer. And so he's curious about that. The second question is from Roman. It's about the EU-UK agreement. And I think that's mainly from Mira, maybe Theodore as well. It's about whether the digital trade chapter is going to reflect the status quo on data flow and data protection that's currently within Europe. And the third question is from Nicholas about whether there's any linkage between data flow and censorship policy in the digital trade chapters. And I suspect that would be for Mira and Graham. And the last one, the fourth one is from Thomas and Urs about the influence China is exerting on data policy in other countries. And so it's mainly for Graham, but I think for other panelists as well. And the final question, I started with Theodore, but also extend to others, is from Julie. It's about the dynamic between Europe, US, and China. And the analogy she uses is the rock, paper, scissors game, where each tries to trump the other. And so he's curious about that dynamic in play. So let's start with Mira.
All right, thanks so much for the very pertinent question. So I'll start with the RCEP. RCEP, there indeed the commitments on data flows are minimal, so it's sort of we will try not to impede them, but there are no firm commitments, and there's a lot of carving out of policy space for the RCEP parties. I think this is important to note because it is sort of a signal to what might happen under the WTO, whether we're going to have a plurilateral or multilateral agreement on digital trade. And indeed, what this signals is that if such an agreement indeed materializes, it's going to be a thin agreement without any substantive provisions on data flows and nor having such provisions on localization measures. So I think this is rather unfortunate, but it actually has also already been reflected in the offers that we have in the communications within the WTO joint statement initiative. Moving on to the next question with regard to the agreement that we have post-Brexit between the UK and the European Union, the Trade and Cooperation Agreement. This confirms the stance of the EU on digital trade. So we have quite far-reaching provisions, including data flows, ban for localization, but also others such as source code, net neutrality, cybersecurity. So also AI cooperation. So this goes even beyond what we have with Australia and New Zealand and Tunisia. What is key here, however, is that the UK must have a data adequacy agreement. So basically an adequacy decision between the EU and the United Kingdom, and data is not going to flow by default between the two entities. And now the Commission and the UK, they have 6 months time to negotiate such an agreement. In terms of the overall impact of the agreement on digital trade, it should be noted that, as you may know, this agreement does not cover all services. So indeed, we might see some negative impact to overall digital trade between the EU and the United Kingdom. Now, moving on to this rather interesting question of whether we have some provisions with regard to free speech censorship in the universe of free trade agreements that we have so far. No, we don't have an explicit provision in any of the existing treaties so far. However, one should mention here that we have indirectly important provisions that may promote free speech and limit censorship. Important here are the provisions on net neutrality. So across different treaties, we have provisions on access to and use of the internet, which basically provide freedom for users to choose devices, networks, etc. These provisions, however, vary as to their bindingness. None of them are truly binding. We have such language in DIPA and the CPTPP, but those are not binding provisions. In the DIPA, other provisions that may be relevant are with regard to the public domain, the promotion of the public domain, as well as digital inclusion. These two, of course, can be interpreted as fostering free speech. Other important provisions come actually from US-led agreements there. The United States is trying to sort of diffuse or export its section 230 of the Communications Decency Act, and has included provisions on interactive computer services in the USMCA and the agreement with Japan, which basically tried to limit the liability of intermediaries. And this is important because in contrast to the United States, as you know, in the EU and other countries, there have been initiatives to actually regulate intermediaries with regard to online misinformation and other sort of phenomena that may limit free speech. So we see here again a sort of a contestation, and this comes again also from the very different perspectives that we have from the EU and the United States on the protection and promotion of free speech. And I'll stop here and give the floor to the rest of the panelists. Thanks so much.
Graham. You're on mute, Graham. You need to unmute.
Just first on RCEP, the way I read that, Mira, was that because the crucial decisions, both in relation to the data export clause and the data localization clause, say in the footnotes to them that the decision about state interests and the importance of them and the genuine nature of them will be left to the states themselves, and that's not found in the CPTPP, that it is a much softer provision, much softer. And so I only am familiar with some of these agreements, not the whole range that you're familiar with. But it seems to me that the USMCA takes by far the hardest line because of the complete ban in relation to localization. Then you have CPTPP sort of in the middle, and then RCEP is really very much at the softer end. I'm pleased to hear that you agree. That's good to hear. The question about the influence of China on the drafting of on some of the provisions in other countries. Well, I don't have any basis of knowledge of discussions between the particular countries. I'm just going on the similarities, textual similarities between the Chinese provisions and those in the Pakistani and Chinese legislation, and similarly in comparing the Russian provisions with the ones in the various countries in Central Asia. It's just one of them in relation to the conditions for data exports stood out as having almost the same wording across all the Central Asian countries as in the Russian one. But I suspect the substance is will end up being quite different because Russia has put in those very unusual provisions about data flows being okay to any country that is a party to Convention 108, which I've never seen anywhere else except in a regulation in Israel that they've just adopted Convention 108 as the text. And also actually having a whitelist of 23 countries to which data exports are. I've never seen that anywhere. So anyway, I'll stop there for the moment, Peter.
Theodore?
Yeah, just two quick points. The first about the EU-UK Trade and Cooperation Agreement. And more generally, well, this agreement has been criticized, the provision concerning the 6-month extension so that as to provide time to negotiate an adequacy decision arrangement has been criticized by some scholars on several grounds, including the idea, and I think that this idea, well, this is a very unique case, ad hoc case, but more generally speaking, as a matter of official EU policy, the issue of data protection should not be addressed into a free trade agreement. There is a huge difference. Well, the instruments that have been discussed by Mira most often are trade instruments talking about free data flows, etc. But these are not in the logic of the EU. This is not the place where you're going to introduce introduce the data protection. So these agreements should comply with the EU framework. More generally, it's extremely interesting to note that concerning all these international cross-border data flows, the EU prefers to go through unilateral decisions. Privacy Shield was not an international agreement. Safe Harbor was not an international agreement. The adequacy decision with Japan or the one negotiated right now with South Korea are not international agreements. They are unilateral decisions by the EU on the basis of Chapter 5 and Article 35 of the GDPR. which means that it's much easier also to challenge them at the Court of Justice of the European Union. And one big question now I'm always asking as an international lawyer working very, very much on issues concerning cross-border data flows and Schrems 2, etc., is why some states like the US, for instance, did not prefer to negotiate a data agreement with the EU directly instead of being held like hostage, as they think, by the unilateral decisions and the process within the Court of Justice. This was the first point. Very, very quickly, the second, concerning the scissors game. Well, gee, I don't know. Definitely one could think that EU is the paper with all this regulation, which comes around all the others, but the EU can become very quickly a rock when you see these huge fines, the 4% of yearly turnover that can come, and this is a huge concern for companies all over the world and a big instrument of compliance. Thanks.
Great. Let me thank all the speakers and turn over the forum to the organizers. Anupam?
Great. Thank you very much. Thank you all for amazing presentations. We will take a short 5-minute break and conclude with our last panel. Thank you again.
Good morning, everyone. And I can say good morning now because we are past midnight. So it is morning for everyone in DC, Hong Kong, and beyond. My name is Brian Tang, and I'm the founding executive director of Light Lab at Hong Kong U, where Light stands for Law, Innovation, Technology, and Entrepreneurship. And I would personally like to congratulate and thank Hao-Chen and Anupam for organizing this fascinating and wide-ranging conference and for inviting me to be a moderator. For your information, I have one great little Light Lab connection with Georgetown Law Institute for Technology, Law, and Policy. And that's our student team won last year's inaugural Georgetown Iron Tech Lawyer Invitational. Alas, on the flip side of today, COVID-19 prevented us from attending the finals in DC in person, the same way that we're not able to meet each other in Hong Kong this time around. I'm honored to moderate the final panel of this conference. On the one hand, it closes off a great conference, but on the other hand, it literally is the graveyard end of the conference in more ways than one. And I'm actually so pleased to see many of you still here, and I presume many of you from this neck of the woods are not doing it for CLE points and the like. So over the past 2 days, the broad and clever title of this conference, Data Sovereignty Along the Digital Silk Road, has seen speakers cover tech, trade, and geopolitics, East-West, North-South relations, and the loaded term colonialism, and the role of the state, corporate actors, and human rights, including to privacy, which with the evolving frontier technologies and business models. Ultimately, this topic relates to power, reach, and innovation, and the underlying hope, I believe, that we should achieve resolution of these wicked problems through increasing trust, peacefully and humanely. My own current research focuses on AI governance, so I believe that it may not be long before we need to also incorporate considerations of the ever more autonomous machines. Our last panel is entitled Regulating the Data Economy, and I look forward to hearing a fascinating panel discussion relating to different aspects of international regulatory innovation relating to the various themes of this conference. But these perspectives are truly varied, ranging from global finance and fintech from Doug Arner to pervasive Chinese e-commerce platforms, or if you like, big tech Chinese style from Liz Liu, from trade agreements from Henry Gao, to sharing economy or decentralization network or peer-to-peer ethos from Xi and Peng. I note that four of the five of us are actually based in this neck of the woods, so particular hats off to all of you who are presenting after midnight Asian time. And as with the other panels, Q&A will be held at the end, so I encourage attendees to please post your questions in the Q&A box for me to address. And Anupam has told me that since we have no panel afterwards, we may have more flexibility in relation to Q&A if there are many questions that come across. First up, can you please put your virtual hands together to welcome Doug Arner from Hong Kong U. He's actually the chap that pulled me into academia, and Doug will be speaking on data regulation and financial regulation in global finance. Over to you, Doug.
Thanks a lot, Brian, and big thanks to Hao-Chien and Anupam for one, pulling this all together, and two, for the invitation to join. I think, as Brian said, this last panel for many of us on the panel, it's pretty late, but I guess in some ways we have to feel better because Graham Greenleaf, who just dropped off, it's 3 hours ahead in Sydney. So he was, I think he stopped at 3 in the morning Sydney time. So I guess those of us where it's just after midnight, we can't complain too much. So let me just pull up a few slides. So what I'm looking at is data regulation and financial regulation in global finance. And in the context of finance, this topic of data has emerged in the past couple of years as one of the most significant topics, one of the most significant compliance challenges. And I'll be referring to a series of related papers, and the work that I'm working on builds on these to focus specifically on the context of the interaction between data regulation and financial regulation. I think really the starting point when we are thinking about this is that today, finance and data, digital data, are essentially indistinguishable. Because of the process of digitization and datafication, when we think about modern finance, essentially it is an almost entirely digital industry. But it is also one of the world's most regulated industries. And as a result, historically, finance has not really focused on data regulation. It is focused on the context of financial regulation instead. And that is something that has changed over the past few years. Now, if we look there we go, getting some slides stuck. Try the slides one more time. Okay, there we go. So if we think of this idea of digitization of finance, we can think of a long-term process, but one that has ended up in one of the most globalized, one of the most digitized industries. If we think about the most globalized aspect of global finance, it's foreign exchange markets, about $6.5 trillion a day changing hands in global foreign exchange markets. And that is almost entirely digital transactions. If we think about securities markets, stock markets, almost entirely digitized transactions. The end result, and this is something that COVID-19 has pretty dramatically accelerated, is a completely digital industry. And I think what is interesting, and certainly something that my colleagues Dirk Zetsche and Ross Buckley and I have been saying for some years, is that one of the most important issues from the standpoint of global finance has been an increasing intersection between financial regulation and data regulation. And in a recent article, we look at how some of these factors have come together in the particular context of the EU, particularly in the context of 2018. And if we think about these measures, because of some of the aspects of extraterritoriality that we've been talking about over the past 2 days, it has meant that the impact has not just been in the context of the EU, but really with anyone dealing with EU customers from anywhere in the world. And the starting point for this was a process that began pretty dramatically in the aftermath of the 2008 global financial crisis. And one of the global reactions to the 2008 crisis was a pretty dramatic increase in financial regulation, in particular relating to disclosure and reporting requirements. And something that we see coming in 2018 in the EU, MiFID II, the Markets and Financial Instruments Directive, which is fundamentally about real-time digital reporting of transactions. What does this mean? It means that financial institutions effectively had to digitize reporting processes for hundreds of millions of transactions in order to basically package this data for delivery to regulators under new regulatory requirements. At the same time, and really discussions certainly in Asia, we began looking at this around beginning of 2017, the impact of GDPR. GDPR in 2018 really was about the first time that the financial sector in much of the world had really thought about privacy, about data protection. And certainly the impact of GDPR from its extraterritorial provisions from the standpoint of financial services providers dealing with the EU from all over the world was tremendous. And basically this process of digitizing data for reporting processes in the context of then linking it to customer data, often in the context of digital identity provisions. And of course, we also get in 2018 a similar process around open banking, requirements for financial institutions, banks, to share customer data on customer requests with pretty much anyone else, but not a bilateral obligation where everyone else had to share with banks, but only banks sharing outside. And what you can see from this is an interplay between financial regulation and data regulation. And in the context of the EU, all of these things were independent processes, but they all came together. And we see a more strategic approach taken in the context of the EU digital finance strategy in 2020. And I think when we're thinking about financial regulation, we have to keep in mind that financial regulation has a very highly developed policy framework from which its various regulatory approaches derive. At the basis is the idea of a financial system playing a key role in development through confidence, through supporting inclusion, and increasingly through issues around national security. It does this through focusing on monetary stability. It does this through focusing on financial stability, on market integrity, on market conduct, which incorporates fairness, customer protection, investor protection, market efficiency, market functioning, and competition. And across all of these regulatory objectives, there is a complex international framework of largely soft law standards coordinated at a policy level from the G20 with technical standards developed by the Financial Services Stability Board, the Bank for International Settlements, the FATF, and others. And from the standpoint of digital finance, there's been an increasing focus in recent years as there has been a recognition of digitization in finance of specific risk aspects coming from that process. And we can think about this, I think, really under the overall rubric of another recent article of ours called Tech Risk, and essentially highlighting data storage and protection issues. This actually in financial services initially starts from resilience questions around, oddly enough, not only 9/11, but even the Y2K problem, some ancient history. More recently, a big focus on cybersecurity and issues around cloud and outsourcing. And it's interesting that if we think about data protection, think about financial services. If finance is entirely data, if you are talking about money, financial instruments, all of these things are digital. The data that you are storing is the business. And what this means is that if something goes wrong, it's not just the customer that is losing, it is potentially a loss of confidence in the financial system, which could trigger a financial crisis. That's a financial stability risk. That, and certainly this was a 9/11 target, was actually also a national security risk. So increasingly, internationally, we can see in the context of cybersecurity being seen as the biggest financial risk for institutions, being seen as the biggest financial stability risk for regulators, and increasingly one of the biggest national security risks. Second aspect is really around data dependence and reliance. As a data-driven industry, finance relies on a wide range of data sources, and actually many of the providers of core data have become increasingly concentrated. Bloomberg, Thomson Reuters, a small number of firms that are providing much of the data to much of the industry around the world, raising a variety of concerns. Data privacy issues are another, but in many ways separate from these other concerns. And if we think about data and financial regulation, because of different objectives, particularly when we're thinking about data privacy regulation compared to financial regulation, we're actually seeing an increasing range of conflicts. And probably the best example where we've seen this on a number of occasions, particularly in the context of the EU, is in the context of AML, anti-money laundering regulations, where there are specific requirements of financial institutions to provide data to regulators about the activities of individuals. And it's something that has actually required to be specifically addressed in the context of addressing privacy concerns. Another interesting area where we're seeing this, discussions around blockchain, most recently around what are called central bank digital currencies issued by central banks, which inevitably everyone designed so far collects a substantial amount of data about their users, and then questions about how this data will be used. Now, in general, it's only going to be used for state purposes, but that's something that is quite different from private purposes. And finally, cross-border activities. Let me think about this for a second. Now, if we think about approaches to data, we've had a number of discussions over the past couple of days looking at frameworks. And I think we've often focused on differences between the EU, US, and China. And what we've actually done is we actually break this down into two levels. You have both the market approaches to data, and I think this is what most of our discussions have been around. If we think about the EU, generally a restricted approach, almost rights-based approach. If we think about the US, a very property-based approach, and China similarly, but often different approaches when we come to the context of government or state use of data. And so one can say that in the same way that there is a restricted approach to private sector use of data, there are also significant restrictions on governmental or state use of data. In the US, while there's essentially free alienability at the moment from the standpoint of the private sector, very serious distrust or restrictions around state use of data. Whereas in China, large freedoms until very recently in the context of use of data in market transactions, but very significant powers enabling the state to collect and use data. And I think when we're thinking about differential approaches to data, it's important to differentiate both aspects and realize that there are a variety of convergences and divergences. So when we're thinking about data localization, when we think about finance, there are actually quite a number of reasons for data localization. National security. It may actually make sense in the context of financial supervision to want to have access to data on financial institutions. And it may be that the only way that can be guaranteed in the context of crisis is it's locally available. Same from the standpoint of financial stability, consumer protection issues, and of course, we've talked about the developmental issues. A second aspect, and this is one where we're seeing some really interesting developments and perhaps a convergence in discussions of approaches to concentration, to data regulation and financial regulation, is around issues of
Good. And this is something that we could talk a lot more about. I'm just going to highlight in the context of Ant Financial actions where we're seeing increasing concerns about the emergence of large concentrations of data and finance in institutions, which raise very specific challenges. Now, if we're looking forward, we're thinking about globalization versus fragmentation. If we think about, from the standpoint of financial services, a long history of regulatory data sharing, which is problematic from the standpoint of some privacy protections, as I mentioned in AML. We have actual obligations for risk data aggregation for cross-border financial institutions, or digital regulatory reporting, where they have to collect data on a global basis and report it to multiple regulators around the world. And localization poses a very specific challenge to this. If we think about trade agreements, finance receives almost inevitably special treatment, exceptions to other forms of trade treatment. So we have specific international discussions on financial data flows at APEC, US, EU, G20. But because of the geopolitical concerns, it is proving very difficult to come to any agreement, including in the simple context of cybersecurity. So if I think we're looking forward, we can say probably some of these approaches to data may be fundamentally insuperable, and we may be looking at continuing fragmentations in the context of data. But from the standpoint of data in finance, there are probably enough commonalities that we may be able to see a common approach to data in finance, even if not to data generally. And one area where we are seeing perhaps increasing opportunities is in the context of certain areas of convergence between financial regulatory objectives and data regulatory objectives. And just to round out, I think it's also interesting that we're seeing some very interesting technological approaches to addressing localization. And of course, large financial institutions, large tech companies have the resources to pursue these sorts of approaches. The simplest is that any jurisdiction which has enough economic activity to justify it is increasingly the situs for a cloud data warehouse. And what that means is, from the standpoint of localization, most requirements can be met via cloud services. Now, that brings with it its own sorts of issues, but it's also showing where the opportunities for decentralized storage and analytics have real opportunities to actually leapfrog some of these issues around localization. Thank you.
Fantastic. Thanks so very much for that sharing, Doug. And as some people know, my background is in finance, so the issue of localization has been a long-standing one for multinationals that have been developing across. And these days, in the area of RegTech, there's that conflict, as you mentioned, between the AML compliance and the privacy aspects as well. Your discussions about China is most timely, and now I'd like to turn my attention over to Liz. Liz is from Georgetown School of Business, and she'll be speaking to us about law Chinese style. Over to you, Liz.
All right, thank you, Brian. Okay, first of all, I would like to thank Anupam and Hao Chen for organizing the conference, and also my thanks to all the conference participants and the people in the audience who really raised many great insights from which I learned a lot. So today I'm going to talk about, this is a conceptual paper joint work with Beryl Angas at Stanford University. This paper is to think about a novel way of legal development by looking at China's e-commerce market, but I think it also fits the conference theme by providing some ideas about the interactions between platforms or firms and the state, because the interactions of private regulatory power and public regulatory power is going to be a very important topic for how data sovereignty is going to be carried out. Okay, so according to Thomas Jefferson, the jury system is a central pillar of the judicial independence that can check the arbitrary powers of the government. Therefore, not surprisingly, China has not yet widely adopted the jury system in its legal system because China is an authoritarian state, and the Communist Party has long resisted the Western-style rule of law, including the idea of judicial independence. However, actually, there has been a jury system in China in the past 7 years. The jury system is privately run by China's largest e-commerce platform, Alibaba's Taobao.com. And until yesterday, over 1.7 million jurors have resolved 16 million cases. And let me tell you briefly how the system works. So when there's an online dispute, Taobao will randomly draw 13 jurors from a pool of volunteers up to 4 million volunteers who are also Taobao users. And then the jurors will review the evidence presented by the disputing party. Such evidence includes, for example, the photo of the products that's been delivered, and also the chat history, and also the all the receipts and delivery proofs. And then the jurors will vote. So they will vote within 48 hours. Whichever side that gets the simple majority vote will win the case. In recent years, Taobao actually experimented with a much larger jury panels of up to thousands of jurors. And they have used this institution to deal with very complicated issues, such as counterfeits, fake reviews, or they even used this jury to vote on some rule changes that made to Taobao's platform rules. But a more interesting fact is that the authoritarian government has not only tolerated, but actually actively promoted the exercise of this jury system that involved mass voting. So here comes the question of why. Why does the authoritarian government, which has proved to be so resistant to the Western-style rule of law, allow or even encourage this private legal system to exist? And in this paper, our answer is this is part of what we call law Chinese style. And the idea is when the national government is unable, for example, due to technical issues, or unwilling to provide a very strong rule of law, it can outsource part of the development of law to key private actors with limited scope. And we argue that Taobao, which is China's largest online trading platform with over 700 million traders, is not simply an exchange platform. It's not simply a copycat of Amazon or eBay, but it has the means to create law Chinese style. And in this talk, I'm going to promote a theory of legal development by drawing lessons from China's e-commerce market. So let's take one step back and set up this talk in some broad themes in law and economics, which is in order to have economic growth, it oftentimes requires a set of strong legal institutions to support the market, for example, secure property rights, contract enforcement. But if a strong legal system is so important to economic growth, why doesn't every state have one? And we provide the answer. We theorized what we call authoritarian legal dilemma to explain, at least in some countries, why this is very difficult to get. So in order to understand this legal dilemma, we first need to make a distinction between private law and public law. So private law mostly deals with relationships between citizens over the issues of property contracts, and private law is very important to economic growth. Public law, on the other hand, mostly deal with the relationship between the citizens and governments over political issues, citizen rights, constitution. And public law becomes a major source of political constraints or constitutional constraints on the leading parties, on the ruler and political elites. For authoritarian government, in the ideal situation, it wants to provide or promote private law because it wants economic development and rents. However, it doesn't want public law to be fully fledged because it will become constrained on the elites, on the political elites. But here comes the question, because in order to fully supply private law, you actually need to establish a strong and independent judiciary that is very functioning in the realm of private law. However, if a judiciary that is indeed strong and independent, it cannot commit to not expanding its jurisdiction to include public law and become a major constraint on the central government and the ruler. Therefore, knowing the consequences, the state will not fully supply private law in the first place because it is very difficult to establish a strong and independent judiciary that will supply, but only supply private law. This is also the reason why, even though China has done a lot of legal reforms and there has been a lot of development in formal market institutions, but there is still under provision of legal institutions, even in the realm of the private law. But in the past, China was able to achieve very high growth by using non-legal substitutes for the formal legal system. For example, a lot of entrepreneurs will rely on personal relationships or guanxi in Chinese to conduct business, which is sort of a substitute for rule of law. And also the government creates a lot of incentives for government officials to compete with each other so that the government officials can actually provide a lot of market-friendly policies to stimulate economic growth. However, over time, when Chinese economy has become larger and more integrated, these non-legal substitutes have become not sufficient to provide enough growth. For example, China right now is highly reliant on small and medium-sized businesses to stimulate growth, but these SMEs actually in a weak rule of law environment, they're poorly positioned, for example, against state-owned companies. Therefore, the rule of law system becomes, and market institution becomes very important. And here comes the law Chinese style, which provides a new solution to the authoritarian's legal dilemma. Just to recap the idea, when the government faced political obstacles and the rigidity of the formal institutions to provide the rule of law through formal means, the national government effectively actually outsourced a lot of legal functions, even the creation of the law, to the key private actors with a limited scope. And in this paper, we talk about how platforms such as Taobao will provide private legal substitute for the formal system. So enter Taobao. I think a lot of you have been are familiar with Taobao. This is how Taobao's website looks like. It may look like Amazon or eBay, but actually Taobao's products are far greater in variety, even including some weird ones, such as a crab, dragon boat, bad debt, core seized assets. And in the past, I think someone can even hire someone to write a Communist Party membership application essay with the cost of less than $1. So some basic facts about Taobao. Taobao is owned by Alibaba, and its business model is more similar to eBay than to Amazon because it doesn't sell its own products, but instead provides the marketplace for a lot of buyers and sellers to trade with one another. And in terms of the overall sales on this market, it's extremely big. So back in 2016, which is a few years ago, its overall sales on this market is already larger than Amazon and eBay combined. It's even larger than Walmart Global, which is the world's largest offline retailer. And this is the founder of Alibaba and Taobao, Jack Ma, him singing karaoke in the company anniversary. But one thing I have already said is that Taobao actually has developed very strong institutions. Part of the reason is that it has to, because China, compared to developed markets, has relatively weak rule of law, and there has been a lot of market problems such as counterfeits. Therefore, people do not really trust the online platforms unless there is a very strong institutional assurance so they can trust and trade. So in the paper, we have a very strong, we have a very detailed account about how Taobao provides institutions to solve at least the 3 major market problems in the e-commerce market, such as contract enforcement, fraud prevention, and dispute resolution, the jury system I just mentioned, which is different, which is stronger actually than the equivalents on Amazon and eBay. And importantly, rules on Taobao or these laws on Taobao are enforceable because during market transactions, the money will be kept in escrow with Alipay. Alipay is similar to PayPal, but PayPal doesn't have a compulsory escrow account as Alipay required. So this is very important for market transactions and enforcement of contracts in the market. And also the rules on Taobao are adaptable to the changing needs of users because users can vote at the House of Representatives for rules. And it's very interesting because in the advertisement of Alibaba, they actually put a picture of US Capitol Hill at the center of the advertisement of this institution. And it says, to make a rule, you have a voice. It's kind of amazing to see this in China. All right, of course, not all the platform rules can be qualified as law. And in order to assess the lawfulness of Taobao's private legal system or its platform rules, we use the framework developed by some legal scholars, the What is Law framework. And then we do find that Taobao is in the process of creating a private legal system, even though there are still some of the qualities that's not quite there yet. But even if Taobao is creating a private legal system or semi-legal system, why doesn't the authoritarian government just shut it down? What is the political logic of outsourcing legal function to a private platform? The first argument I already gave, which is this way of developing sort of market institutions and rules is much less politically constraining, much more flexible than directly reforming the formal legal system, which involves a lot of political barrier. And the second reason, which I think is very important, is that this kind of outsourcing activity actually parallels with China's earlier reforms, because the Chinese government, especially the central government, used to outsource a lot of economic functions to local governments. The central government outsourced functions to local governments and let the local governments to experiment with the nature of policies, different kinds of economic policies, so that on the one hand, the central government can reap the benefits that's created by the local government's reforms. And second, importantly, the center can distance itself from failed experiments if the policy just like fall out. Therefore, this is kind of like a blame ducking mechanism actually underscore this activity of the outsourcing. And a third argument, which is in fact, the central government relies a lot on the local government for collecting information, market information, and also enforcing policies. But there are a lot of questions about whether local governments actually report the real information, whether there's any distortion in policy enforcement. Therefore, relying on national platforms, which essentially have a common market, can give a central government an additional tool to collect the information and also enforce policies, which also help the central government to re-centralize its power to some extent. So one trend is that this kind of outsourcing from the central government to platforms has become more explicit over time. For example, in 2017, the Anti-Corruption Bureau has signed a memorandum with Alibaba. And the memorandum basically aims at curbing commercial bribery. And basically the government is going to the government will provide Alibaba with information about businesses and individuals that got involved in commercial bribery. And with the information, Alibaba can legally prosecute these people and organizations when they transfer money online or when they do business on the platform. So I just talk about how the law Chinese style work, which is sort of the government outsource legal functions to platforms. But this actually points out a broader concept, a greater like a more scaled up phenomenon that we observe in China's digital economy, which is also a concept I wrote in my book manuscript, which I'm still writing it. This is a concept, so basically, this is a phenomenon I call institutional outsourcing, because right now the Chinese government has not only outsourced legal functions, but also political functions and social functions to platforms. For example, in terms of censorship, the government doesn't do it itself. It outsourced outsourced most of the censorship functions to social media platforms. And also health code that everyone is familiar with was actually developed by Tencent, Alibaba, and all these tech firms. Therefore, Taobao is a special example of what I call a very special type of private actors that's serving the function of the government, the private regulatory intermediaries in my book. So this kind of outsourcing activities from the state to platforms actually gives rise to a new governance model, which is we call private governance under state oversight. So the idea is that in certain governance areas, sometimes the government basically has no capacity to do it. The government actually allows or even encourage multiple key private actors, and in this case, the platforms, to provide competing and overlapping systems of private governance so that citizens can benefit from. But the key of this is that these systems of private governance has to compete with each other, and the citizens cannot just be locked in with one platform. It has to have the mobility across platforms so that you will create enough incentive for platforms to provide good governance. In other words, the key is that the state must prevent one single platform from becoming a state-franchised monopoly and keep the market competition across platforms going. Otherwise, the quality of the governance, private governance, would definitely decline. So this is sort of a theoretical explanation of what we are observing, I guess, with observing in China right now, this anti-monopoly initiative, even though I don't think a lot of these platforms has reached the status of monopoly yet, but definitely government is very aware of this. So to conclude, in this paper, we talk about law Chinese style as a very interesting route to legal development, and it is a less politically constraining approach to legal development than the Western approach. And we also think that this kind of a concept probably can travel to other countries because a lot of developing countries, especially authoritarian countries, they face political barriers to develop very strong market institutions. And given that technology is growing everywhere in the world, e-commerce is a global trend, maybe this is a general digital solution to the lack of rule of law in many countries in the market. And going back to the theme of these conference, I think my paper actually points out, even though it's in a domestic market, but it points out some of the more general themes, especially the interactions between the state and platforms, the regulatory. When we talk about regulators of data, I think a lot of panelists have already said that we also need to take consideration of these platforms and private actors and how they interact, whether they always go together or they compete with each other is a very interesting question. Thank you very much. And I look forward to your questions.
Fantastic. Thank you very much for that, Liz. Again, it brings in lots of different facets that had been discussed previously and really widens that concept of sovereignty as well, right? That as I said, the conference organizers have very cleverly incorporated into the different aspects. Next up, we've got Henry Gao from SMU Law, who'll be discussing yet another perspective of data sovereignty, and this time in relation to trade agreements. Over to you, Henry.
Thank you, Brian. I just want to make sure you can hear me. Okay, great.
All good.
Thank you. So I want to start, like other speakers, by thanking Anupam and Hao Chun for organizing this great conference and inviting me to the conference. My title is Data Sovereignty and Trade Agreements, Nailing Jello to the Wall. Now, This JELO and war was mentioned first by Bill Clinton when he was trying to persuade the Congress to approve the US-China bilateral deal that paved the way for China's accession to the WTO. He was referring to China's effort to try to regulate the internet. And he was saying that the Chinese could not regulate the internet, just like you could not nail the JELO to the wall. But actually, in retrospect, as we look back 20 years after China's accession to the WTO, you could argue that Bill Clinton was actually giving a hint to the Chinese leadership to actually build a wall to regulate the internet, because indeed 3 years after Bill Clinton said this, the Chinese built the Great Firewall, which is still in operation today. So I will start by tackling the issue of sovereignty and data sovereignty, a very important issue that has been discussed at length by speakers today and yesterday. Now, with regard to sovereignty, there has been, as many speakers alluded to, many different interpretations and definitions. For example, if you start with Bodin, who was the first person to create to use the idea of a sovereignty, and he regarded sovereignty as the most high, absolute, and perpetual power in a country. And then if you look at Vattel, who is regarded by many as one of the founding fathers of international law, he took the external dimension of the sovereignty by saying that sovereignty is basically something that is exclusivity of authority without. So in other words, sovereignty is an independent authority that is independent from any external influence. And then Schmidt, whom I think another speaker mentioned yesterday, he referred to the power to decide on the exception as the defining feature of sovereignty. And then more recent scholars like Lessig in his Code 2.0, he referred to sovereignty as control. And actually, if you look at the way many presentations were presented over the past 2 days, you could see that the control definition with regard to sovereignty seems to be becoming more and more popular these days, with many people referring to all these big tech companies as the one that has really cyber sovereignty on people's data. Now, sovereignty is a massive business. How about the data sovereignty? For data sovereignty, it is even more difficult to define. It is, as what Ding Fu mentioned yesterday, a so-called oxymoron. Because first of all, data, as we understand it, normally data is invisible and it easily transcends border. And sovereignty is normally confined to within borders. For example, me as a speaker from Singapore speaking at a conference hosted by Hong Kong U via US online meeting platform with servers that are based in China. Now, which country among these four should claim sovereignty over me if I see something that is disrespectful of Singapore or the US? So the difficulty to define is noted by many authors, and actually some scholars have tried to define this. For example, Patterson in one article on data sovereignty tried to give a definition, but his definition is more of a technical definition, as we can see here. So it is not really suitable for my purpose. But I would argue in my presentation that our task is not really to define data sovereignty, because we are not really trying to nail JELO to the wall here. Instead, we merely have to decide what happens when the JELO hits the wall. That is, we merely have to decide data sovereignty in the context of trade agreements. When data are being traded, then that is the point of time that we have to define these issues. So I would define data sovereignty as the highest independent power over data trade that can define rules as well as exceptions, especially regarding two types of issues. The first one is the border measure, especially relating to cross-border transfer of data. And the second one is domestic regulation, especially relating to data localization. Now, many speakers have alluded to this, so I will be brief here. I think that is one of the benefits of being the second to last speaker to speak in the whole conference. If you look at how countries deal with the two different issues I mentioned concerning data sovereignty in trade agreements, you can basically divide them into three models. The first one is the US model, which when it comes to the two questions, whether the advocate of free flow of data and whether they advocate of prohibition on data localization requirements, answers to both are yes. So their data sovereignty regime, I would call a firm sovereignty because they basically give the sovereignty to the firm. And then if you look at China is the exact opposite of the US because China would say no to both questions. And here I would call the Chinese sovereignty regime a state sovereignty regime. While the EU is somewhere in between because the EU, when it comes to free flow of data, the EU says yes. But when it comes to prohibition on data localization requirements, the EU says no. But the EU has a very important but for both of these two questions. So yes, but, and no, but. And here I would call the EU's regime individual sovereignty because the EU really try to give the power back to the people, back to the individuals who are using all these online platforms. So let's quickly go through the different approaches of the three players. For the US, as I mentioned, their key is to ensure free flow of information across the border. And also they are keen on ensuring that data localization requirements are not allowed in the domestic regulations of their trade partners. Now, with regard to privacy, they do not have a comprehensive privacy protection framework. Instead, they only have a patchwork of sector-specific laws regarding specific issues. So if you look at the trade agreements, again, I will quickly skip through this here because many speakers have mentioned this already in the interest of time. But we can see that the US approach is reflected in its RTAs, especially the TPP and the US MCA provisions. And also in the TISA and the ongoing WTO Joint Statement Initiative on e-commerce, the US has basically affirmed the same positions. Now, with regard to the EU, the key issue for them is privacy as evidenced by the GDPR, which is probably the most strict privacy protection legislation in the whole world. And also they try to have an thorough reach of their regulations by requiring adequacy decisions in countries which conclude a free trade agreement with them. There was a bit of a hiccup before 2018, but they were able to sort out the difference between justice and trade. And now they have a common position on regulation of data issues in trade agreements. But when it comes to the actual FTAs, actually the EU tend to take a much softer position. They do not really require, like the US, to have a free flow of data immediately. And also there were not really strict requirement on privacy protection as one would expect from the strict rules under the GDPR. Now, with regard to China, the key, as I argued in another article, is a cyber sovereignty. And President Xi himself actually has elevated cyber sovereignty to the level of state security and also national sovereignty. So this is something that the Chinese regarded as most important. And because of the censorship, there's no free flow of information, and the Chinese do not have a strong privacy protection framework. And even in the existing privacy protection framework, there are extensive exemptions to the government. And also recent Chinese regulations have introduced data localization requirements. So if you look at what China has been doing when it comes to trade agreements, the Chinese has been very reluctant to include provisions on data localization and free flow of data. Instead, they tend to focus on what the Chinese call trading goods facilitated by the internet. That is traditional e-commerce issues rather than really digital trade issues. So why the difference among different players? I argue that is because one, they have a different interest. For the US firms, if you look at the biggest digital firms in the world, among the top 10 firms, 6 are US firms and 4 are Chinese firms. So who are the US firms? They tend to be firms like Facebook, like Google, that really only trade in digitized products rather than physical products. But if you look at the Chinese firms are mostly firms which specialize in traditional e-commerce firms like JD.com, like Alibaba. So these still do traditional trading goods, but it's just that they are doing this through the online platform. For EU, no single EU firm is on the list. So that explains the different approach, because US firms want to export their platform. So therefore they want to tear down the barriers to digital trade, while the Chinese firms are most interested in actually the barriers facing traditional trading goods, while the EU firms they want to in a way try to fend off the threat from the American and Chinese firms. That is why some people have been arguing that the GDPR actually is disguised trade protectionism, just a way for the Europeans to make sure that the American and Chinese firms would not capture all market share in the EU. And also another reason is because the three players have a different regulatory philosophy. For the US, they have long held that the internet and the cyber sector should self-regulate, should be carved out basically from government regulation. While for China, there has been a history of a heavy government intervention since the very beginning, back in 1994, when the internet first started in China, where, as I argued in another paper, it started from regulating the hardware and then the software, and then the platform and the data. And for the EU, they have a strong tradition of a protection of human rights because of the atrocities of the Second World War. That is why they place privacy as a human right as the most important value. And these three models, as I mentioned earlier, are not limited only to these three countries. Instead, according to a recent paper, excellent paper by Martina Ferrican, whom I think is in the audience, and Eric Marvel, as you can see around the world, there are these three models, which basically can include every country in the world. And in their paper, they give different names. For example, they call the Chinese model control model, the EU model regulatory model, and the American model the open model. But I think the idea is the same. So even though with all these different approaches, I do not think that it is impossible for us to reach some sort of agreement, because we start to see convergence of different regimes. For example, in the US, with the recent banning of TikTok and WeChat, you might argue that the US is borrowing from the Chinese playbook. While for the EU, they have no adequacy decision or data flow and localization provisions in the latest FTA, the one which that then. And these might indicate that the EU is not really so keen on privacy protection as one used to think. And for China, in the recently concluded RCEP and also in the Hainan Free Trade Port, the Chinese authorities have agreed to kind of, in the RCEP, they agreed to rules prohibiting localization requirements and also allowing free flow of data across the border. And in Hainan, they also said that they are trying to experiment with new models of data governance. So all these probably tell us that maybe we are seeing a great convergence, just like what this photo is showing us. You know, I used to think that the Chinese are the best in the world in terms of climbing walls until I see this photo, which was from yesterday, where all these people in the US are more adept than any Chinese I know actually at climbing walls. So to conclude, I hope that you would agree with me that I have successfully nailed the Jello on the wall, and we can discuss more about the Jello on the wall later. Thank you.
Thank you very much for that great presentation, Henry. And I love that you managed to even get an up-to-date photo of what's going on in DC into your presentation. So very, very, very timely indeed. Last but certainly not least, please welcome Xinyi Peng from National Tsinghua University, who will be talking about the sharing economy and its enemies, regulatory divergence, cooperation, and sovereignty. Xinyi, please take it away.
Yes, thank you, Brian. Good morning, good afternoon, good evening, wherever you are. It's a great pleasure for me to share this panel. In the following presentation, I will point out the divergent legal approaches to regulating sharing economy activities. And I will argue that the differences in services, requirements, and standards become more significant as trade barriers. And I will raise the question of how international economic law can discipline local regulation. Is international cooperation possible? And how regulatory cooperation arrangement may be confronted with a loss of digital sovereignty. As a starting point, let me use the case of Uber in Taiwan as an example that the conflicts between Taiwan's government and Uber goes back to Uber's entry into Taiwan's market almost 7 years ago. And from the beginning, there was a strong backlash from the traditional taxi drivers and the taxi companies, which see Uber as direct competition. And angry cab drivers surrounded the parliament in capital Taipei, demanding the government to kick Uber out. The government's position was actually quite clear that the Uber is registered as an information service provider, but what they are doing is actually transportation. So higher court also found that the Uber's business is in fact hiring drivers to transport passengers for money, and they see it as taxi company. So until today, the dispute remain unsettled. And a similar story took place in Japan, that Japan legalized home sharing around 2 years ago. And pursuant to the new law, Airbnb hosts have to register their listing in order to maintain an active status on Airbnb. So Airbnb canceled like thousands of reservations after the implementation of the law. So sharing economy, okay, also called collaborative economy, covers a variety of sectors and is rapidly emerging around all over the world. And people are becoming increasingly dependent on platforms that facilitate peer-to-peer exchanges. For the economic perspective, I would say the sharing economy creates value in many ways, that for by giving people an opportunity to use others' car, apartment, and other properties, is allowed underutilized asset to be put more efficient and productive use. And by lowering the cost of finding traders, it cuts transaction costs and expand the scope of trade. And the essence of sharing economy is that it uses online agent to create market in property and jobs that were not nearly as effective previously. So as a result, people, particularly those of modest means, can more easily enter market with new supply. However, obviously that at the same time, it has created tensions between the new service suppliers and existing market operators. And for example, it's apparent that the yellow cab are losing market share. So the question here is Uber a taxi service or not? Shall the city authority enforce the existing taxi regulation on Uber? I think the real question is how to regulate intermediaries. And in the context of international economic law, the key question might be whether the relevant mechanisms under WTO or free trade agreement can serve as effective tool to prevent arbitrary administration, to prevent discretionary abuse, and to prevent regulatory overreaching. So the interesting thing is that the regulation is not the trade barriers per se, right? But the regulatory divergence may unnecessarily hinder trade in goods and services, limit investment flows, fragment global value chain, and reduce economic growth. Differences in requirements and standards become more significant as trade barriers, as I mentioned earlier. And service suppliers may confront significant challenges when trying to comply with diverse, behind the border measures. So in the case of Uber, as shown here, that various regulations include the cap on cruising, minimum fare, congestion surcharge. The regulations are divergent between countries and even within countries. So it therefore raised the question as to how the regulatory cooperation mechanisms, for example, the chapter of regulatory coherence under the CPTPP, and the regulatory cooperation chapter under the CETA, and the good regulatory practice chapter under the USMCA. How can those regulatory cooperation chapters help? As you are familiar, that the idea of eliminating undue regulatory divergences between countries through international agreement is not new, but deeper regulatory cooperation has come to dominant recent RTA negotiations. But my research, however, would like to point out that the challenges of achieving international cooperation is greatest in areas where divergent social preferences and legal approaches are taken towards similar problems. The key regulatory challenges here is whether we should create a regime which ensure the so-called level playing field. On the one hand, the incumbents seek protectionist, I would like to say the protectionist measures from local and state governments to prevent their markets from being disrupted by sharing economy services. Traditional suppliers may, they must satisfy a number of regulatory requirements, and they asserted that failing to apply those those requirements to sharing economy suppliers can undermine the realization of the goals underlying those regulations. So this kind of assertions actually suggest that existing regulations should be applied to new entrants because they provide service similar to those provided by the traditional providers. But on the other hand, the rapidly evolving nature of sharing economy requires a regulatory approach flexible enough to allow adaptation to novel and potentially unforeseen situations. So some local government emphasize that regulators should appreciate the uncertainty surrounding the regulatory decisions arising from the factors such as the early stage of development of the sharing economy. So it's evident that assessing whether and how to regulate sharing economy activities requires regulators to balance competing objectives. And in this context, I would say social preferences are particularly important to regulatory cooperation because shared social preferences provide a basis for establishing a framework of shared regulatory objectives. And another big challenge is the divergent business models of sharing economy activities, that policy position that all market participants competing in a particular sector should face the same or similar regulatory requirements raise the question of whether differences between incumbent and the sharing economy platform-based suppliers may warrant different regulatory treatment. The answer to this question, however, will necessarily turn on assessment of differences and in WTO language, the likeness between traditional and innovative services. That being said, the ECJ judgment are useful here. That the ECJ rules that Uber service is a service in the field of transport, and in the view of the ECJ, Uber's the commercial offering consists of more than an intermediary service. And because Uber exercised a decisive influence over the conditions under which the drivers can provide their services. So according to the ECJ, Uber's activities should therefore be regarded as the intermediate services forming an integral part of an overall service. And the main component here is transport service. However, in contrast to the Uber ruling, in another ruling, the ECJ qualified the intermediation service offered by Airbnb as an information society service. And the different legal assessment of the two intermediation platforms is particularly due to their ability to influence the respective service provided. The ECJ assessed Airbnb's business model the other way. It says that Airbnb's intermediation service is in no way indispensable to the provision of accommodation services. So it remains to be seen that how the EU new the Digital Service Act will set out effective means for all actors in this online ecosystem. But finally, I would like to point out the divergent legal approaches. In the United States, the differential treatment between Uber and the traditional taxi is leading to claim from the traditional taxi industry that is unfairly burdened by a much more heavy regulatory regime than the new entrants, and some of which are formulated as legal claim invoking the Equal Protection Clause. Among others, I like this ruling that Judge Posner in his very interesting reasoning ruled that there are enough differences between taxi service and Uber service to justify different regulatory scheme. And he pointed out that the different services do not always require identical regulatory rules. So I think my point is that the fact that Uber is largely out of regulatory reach in many cities and in many countries demonstrate how divergent the legal approach are. By the way, let me introduce my dog, Precious Black. She's now sleeping under my desk and wondering why I'm talking to my computer screen in the midnight. Here I would like to point out that in order to respond to the overarching question of this conference as framed by our conference organizers, I would like to highlight the complexity of the interaction between regulatory cooperation and the regulatory sovereignty. That in my paper, I argued that an obvious challenge is the inherent sensitivity of interfering with other parties' sovereign right. In this context, particular attention should be paid to the soft legal nature of several provisions under the regulatory cooperation chapters in the FTAs. Arguably, as shown in this chart, that the existing regulatory cooperation agreement were politically motivated by the desire to have a vaguely drafted requirement and to leave plenty of rooms for individual interpretation, given the highly divergent political, economic, and social circumstances of the parties. So to conclude that, I would say, after all, regulatory cooperation agreement may erode democratic regulators, domestic regulators' right to initiate new legislation, right? So we have to bear in mind that countries have different public policy objectives and therefore adopt different regulations. So regulatory differences across our countries is to a large extent manifestation of democracy and sovereignty. And just very quickly, that to conclude, regulatory decision-making implies the exercise of states' regulatory autonomy. And considering the divergence business model, social preference, and legal approaches associated with sharing economy, I would say a more realistic approach would be to develop issue-specific, step-by-step regulatory cooperation to permit gradual convergence in regulation. And in this context, I would like to mention OECD model rules, which released in last July, that requires sharing platform to report information to tax authorities about sharing platform users' income from different services. So I'm of the view that this kind of issue-specific regulatory cooperation may prove to be a more realistic approach. I should stop here. Thank you very much.
Wonderful. Thanks so very much for that, Xinyi. And now we come to that time of the night, if everybody, all the panelists can come and we can see your screens here, to respond to some of the questions that we've seen that have been posed. Quite a few of them, I think, are posed over to you, Liz. So, and maybe if I can paraphrase some of those questions, because you've raised provocatively that, you know, perhaps these the model that China is using can be used in other developing countries. So in some ways, it raises, if I were to extrapolate from those questions to apply more broadly, firstly, some sort of private-public partnership of sorts, right? And therefore oversight and accountability of that privateness when you use private infrastructure for this. And, you know, in whether it's in the US and in Europe, there are different perspectives on that. And in fact, one might say that in 2021, you know, it's the year of the antitrust suits against the big tech. But it seems like in China, maybe it's going in a different direction. I don't know. The Ant Financial situation might imply otherwise. But yeah, maybe you could respond to that one. Thank you.
All right, thank you very much, Brian. Yes, I think one of actually, when I was presenting this idea at a management science conference, another professor, he presented something that sort of fits into this outsourcing story because he was talking about in Africa when there's constant violence. So basically safety is an issue for people who are on the cap. Some of the companies are having their own versions of, for example, these safety certificates for the drivers, and the government is interested in collaborate. So I think there are a lot of things that I definitely see there's increasing private and public partnership in providing governance, but not in the traditional sense that we're thinking about. It's about writing rules. Because if you look at the e-commerce market, actually Alibaba, JD, or even Tencent has made a lot of inputs to the, for example, the new e-commerce law, which actually has a very special version of, they have 4 different drafts, and one of the drafts was made by the e-commerce business association, which basically has the people who had used to work with Alibaba closely or some other tech firms. So I do think that there is emergence of private and public collaboration. But of course, the question is whether, for example, in a country, say a developing country, it may have the same fortune as China to have a very big, large tech, a domestic champion, basically able to provide a lot of institutions. And there might be a foreign platforms that can do the same. It really depends on whether the state will, to what extent the state can actually trust this foreign tech. I think maybe, who knows, depends on whether the state can actually regulate the data that the platform has. I definitely think there are different routes. And so I just raise that question just for future research, but I think it's a very interesting route we're seeing right now. Sorry, just add something about Ant Financial. So as I said in the second to last slides, I think one important thing for this outsourcing to work, especially to produce economic efficiency rather than negative economic impacts, is that you need to have very vibrant cross-platform competition. Otherwise, the platform, if it is a monopoly, it will do all the things that a monopoly do. So I think that's one of the reasons we see a lot of controversy in terms of 二选一. So basically, they try to use some terms that the users and merchants have to choose one platform over the other during sales days, and that's anti-competition. That's why the government is trying to actually kick in and keep the market competition vibrant. So I think it really fits this paper in different ways. And right now we're seeing another aspect of this. Thank you.
Great, thanks, Liz. I was wondering whether any of the other panelists would be interested in commenting on the private, public kind of partnership, kind of governance models in its different forms that may be emerging. And then secondly, on this, the complication where it's foreign, again, the phrase colonial has been used throughout these few days. Traditionally, it's been talking about the fangs out of the US. And one of the comments is that, well, Europe doesn't have any of these national champions yet, which is part of the problem. Whereas China, of course, does have its own as well. So we'll throw it out to the other panelists to respond to that.
Brian, if I may, regarding the public-private partnership, actually, I wrote an article on public-private partnership in trade agreements concerning China. And my article, which was published a few years ago, mainly focused on, the partnership to deal with the foreign trade barrier investigation and also to deal with the foreign trade remedies cases. But more specifically in the context of data governance, I've noticed also this partnership recently, and actually I discussed this in another paper on China's approach to digital trade, where this was included in my presentation, in my PowerPoint, the slide on EWTP is an example, but I didn't expand it because of time. So the EWTP, the Electronic World Trade Platform, actually started out just because Jack Ma mentioned this in one of the meetings. He said we wanted to build this EWTP. Initially, he said EWTO, but then he changed it to EWTP. And then after he said that, actually the bureaucrats in the MOFCOM started to work on this. And in the end, they were successfully included this not only in the G20 declaration, but also as an official WTO initiative where the Alibaba and WTO and World Economic Forum signed a joint initiative to promote this EWTP. But now with Jack Ma, being vaporized for the past 2 months, I'm not sure what's going to happen to the EWTP. And also another major architect of this initiative, former Director General of the WTO, Azevedo, is also gone from his position. So I'm not sure people are still keen on pushing the initiative. So that's a very interesting episode. Yeah.
Fantastic. Thanks for that sharing, Henry. Anyone else would like to speak to either of these points?
Okay, so sorry. So maybe I can put a footnote here that one angle about public-private partnership is that it's a part of stakeholder involvement. However, maybe I would like to look at this from the other angle that not all private sector enjoy equal opportunities to participate in and influence over policymaking process. And in reality, that industry associations become active players in the process of drafting regulations and posing the risk that the regulators might respond to the one-sided demand of interested groups. And may I also use the case I just mentioned in my presentation that, for example, I think it's obviously that the reality is the incumbent often seek to protection seek out protectionist measures from the local government to prevent their market from being disrupted. And this kind of effort are frequently successful because state or local regulators often fall victim to regulatory capture, and the new entrants may lack sufficient resources to fight back. So that's my comment about the stakeholder participation.
Yeah, can I add something? I really like the Xin's point, because I think right now when we're looking at, for example, suspension of anti-IPO, we are always like looking at the negative impacts on Alibaba. But on the other hand, as we say that large firms sometimes would love to have some regulations because they're the only ones who can shoulder the cost of complying with the regulation. I'm not saying that there isn't any short-term cost on these tech giants. They are hugely. However, in the long run, they may be benefited because smaller players will be driven out of the market because they cannot afford the cost to comply with the new regulations.
Yes, so Doug may speak to this as well, but we do a bit of work in the fintech space, and that's it. For example, in blockchain now and distributed ledger, the established players want more regulation because they can afford to, and to address that, whereas the smaller players might not be able to. The other side observation I might have there is that one difference is that in China, because of the nature of the Chinese style or Chinese characteristics, you do have the large firms who actually then have government officials actually on their boards, right? Which is not, you don't necessarily have, although that may or may not be linked to one of the questions that came in the Q&A, which was asking a little bit, I think tangentially, but there is an intersection about Facebook and the oversight board. So in some ways, that is a new style of governance that doesn't have a governmental element to it, but it's trying to get more stakeholders, as Shini was talking about, right? So different kinds of, civil society stakeholders to be on that, query how much power that may have in terms of governance and the like. We've seen Google has had some hiccups when they tried it beforehand. Wondered whether anyone wanted to take up that particular question. I think that question is more about different kind of governance models, not necessarily with government, but just different ways from if you like, almost part of a self-governing kind of self-regulatory kind of approach. Any interest in taking that up? If not, I'm quickly looking to see if I have missed any other questions. But the time is late. It's 1:43 for those that don't know, for most of us on the panel. Anupam or Hao-Chun, is that enough to call it a day or an evening, as the case may be?
Thank you all for a terrific set of presentations. And thank you, Brian. You're a fantastic and fun moderator. I'm sorry that we cannot be going out at 1 a.m. To celebrate, but I hope that you have a wonderful year this coming year. And thank you to all the participants, the speakers, and the guests. I think it's been wonderful. Hao-Chun, I wanted to give you the last word. I'm putting you on the spot, Hao-Chun.
Yeah. Well, thank you so much to everybody. I think it is such a wonderful conference, and I just quickly want to share that the place where this conference was originated. Anupam and I actually visited Shenzhen. We last year, and we visited Tencent and Ping An Technology. Of course, we visited Microsoft earlier, and so after the visit, we decided to do something more. So here came the conference. And so from Shenzhen, Hong Kong, and to DC, across the Pacific Ocean, and now the pandemic, we overcame the pandemic, and so I think we have accomplished so much through this conference. And so I want to thank everybody again, and also congratulate everybody, for presenting wonderful papers. And I also want to thank audience for participating and for being patient. Thank you so much.
Thank you. And I'm going to add one more thing to Hao-Chen's lovely comments, which is that we also met with Ant Financial, which is a fascinating, and Ant has become the center point of many of these concerns the last few weeks, in fact. And for those in the audience, I also want to encourage you to look out for a book that will come out from Oxford University Press sometime, hopefully soon. And will be also, the remarkable thing is we've negotiated with Oxford University Press that it can be published online for free. So we really hope that you download it or buy it, either way, but we'll be glad to see these papers in print. And I think every one of the papers makes an enormous contribution. So thank you again.